I want to welcome you today on behalf of, we have many sponsors and we want to be sure and thank them, the American Association of University Women, the Waukegan chapter, the Lake County Bar Association, and the Lake Forest College Ethics Center. And we're delighted to be sponsoring this very important meeting today. I'm Melanie Rummel. I am a member of the League of Women Voters, as well as a number of those other organizations that I previously mentioned. For those of you who may not know, the League of Women Voters is a national organization with over 800 local and state chapters, and the League just recently celebrated its 93rd birthday, which is quite an accomplishment. The League's mission is to educate voters and involve them in the political process and in government. We have a lot of activities throughout the year. If you are interested in government at any level, or in public policy, or in being engaged in the political process, please think about joining the League of Women Voters. We'd love to have you. Membership is open to both men and women, and in fact, we have a number of men who are members of the League of Women Voters. I think one of them may be sitting here in front of me. Are you a member of the League of Women Voters in Deerfield, I think? Also, if you would like to support the League's work by making a donation to help offset the cost of these programs, they do cost us money, there's a donations jar and a remittance envelope in the back of the room. And this program is being video recorded by our friends at Lake Forest TV and will be shown on channels 17 or 19 on our website and on YouTube. So thank you for coming, and please watch our website and the media for future public programs. The League does a wonderful job on political forums and candidate debates as well, which many of you may know. I know we have some people here in the room who have been part of those debates in the past, Scott Drury being one of them. Mike Rummel, who is our Lake County Board representative in the back of the room, is also participated in League debates, and they serve a wonderful public function. First of all, I would like to go ahead and introduce Scott Drury. Scott Drury is the Illinois State Representative for the 58th District, elected this November. The 58th District includes all or parts of Bannockburn, Deerfield, Glencoe, Highwood, Highland Park, Lake Bluff, Lake Forest, Lincolnshire, Northbrook, and North Chicago. Scott succeeded former State Representative Karen May, and he is a former Assistant U.S. Attorney for the Northern District of Illinois, where he prosecuted and convicted criminals of all ages, including a high-level member of former Governor Rod Blagojevich's administration. He also prosecuted white-collar criminals, child sex offenders, and drug dealers. A nice group to be hanging with. He has already been active in Springfield, where he has sponsored bills dealing with public corruption, and it unanimously passed the Illinois House of Representatives. He introduced House Bill 2953, which requires convicted public officials to return to the state any public money they earned between the time they committed their act of corruption and the time of conviction. He also was a principal co-sponsor on House Bill 2691, which creates the crime of theft of public funds in Illinois, a weapon that has been available to federal prosecutors but not to states' attorneys. Scott received his law degree cum laude from Northwestern University, where he is also now an adjunct professor, and he received his undergraduate degree from the University of California, Berkeley, with high honors, and he is an attorney with the firm of Reed and Smith. And Scott is kind enough to come up and talk to us now about some other legislation that he's sponsoring.
I don't have my... Good afternoon. Thank you all. Thank you to the League for sponsoring events like this. I know they did one last year during the race for state's attorney, and there was a good turnout like there is today, to talk about this very real and very important issue of wrongful convictions. As you heard from my brief bio there, I come at this, I'm a former federal prosecutor, but I believe, as someone who prosecutes, and sometimes people are surprised by this, that what goes on with wrongful convictions in Illinois and across the country is just absolutely, absolutely horrific. As a prosecutor, I couldn't imagine if I was on the wrong side as a prosecutor of one of those, knowing that I took away someone's liberty and put someone in jail who didn't belong there. So there's been people who have been surprised that I've picked up the torch of wrongful convictions on the legislative side, trying to both prevent wrongful convictions on the front end and also some legislation to try to correct the problem if in fact it has happened. And unfortunately, I think as you'll hear today, and I've worked with the Center on Wrongful Convictions on other issues, it's happened in the past. We need legislation on both the front end and the back end. So I currently have 3 bills pending in the House of Representatives right now. One piece of legislation is to expand the number of crimes that police officers are required to record when they have a person in custody. It was then Senator Obama, now President Obama, who originally proposed the legislation that passed that requires recording for homicides. If there's a homicide investigation, those interrogations, when someone's brought back into the room, they need to be video recorded. One, to prevent wrongful convictions, because we hear in a lot of cases the person is 40 hours, and untoward things happen. But what I know from being on the law enforcement side is that if you assume that the police are doing a good job, and I do assume that having worked with police, this is also a good system for law enforcement. It makes everything more efficient because the false accusations against the police are now on tape. The police officer beat me up. No, he didn't. And so the system will move more efficiently. So Mike keeps cutting out, I apologize. I've proposed increasing the number of types of crimes that are recorded, not just to homicides, but to the highest types of felonies, high-intensity felonies, kidnapping, sexual assaults, aggravated battery, armed robbery. There's a full-page article in the Tribune about this legislation. What you find is that everyone agrees that we need to do more recording, but the fact is law enforcement doesn't always want to do more recording because they claim that there's a big cost to it. And I think there is, but there's a big cost on the back end when you wrongfully convict somebody, and I think those need to be offset. And my line has been, what is the price of justice and what is the price of taking someone's liberty away from them? And that always needs to be put on the scale. So that legislation is currently pending. We're hoping that it's going to get through. There's always talk about wrongful convictions and needing to record in DNA evidence, but one of the biggest causes of a wrongful conviction is actually a misidentification in an eyewitness case. And I've also proposed some legislation that would change the way lineups are done. And what this would do is instead of the officer conducting the lineup actually knows who the suspect is, you have it's called a blind lineup. So the person in the interrogation room doesn't know who the suspect is, so he or she can't try to lead you towards that person. Again, I'm not saying there's any bad efforts on the part of the police. It just maybe they want to get the right person, and they may indicate or say, take another look at number 4. And so that would be removed from the process if we had a blind administrator. The legislation would also call for the lineups to be recorded so that you could hear how good the identification was. What did the witness say? Were they completely positive? Were they kind of unsure? Were they unsure and became positive? All of this could go away again if we record the lineups. And again, there's been some opposition to this on the law enforcement side, saying that it might be impractical, and we're working on doing this. Now, it's important to know that people campaign really hard all over the state on wanting to stop wrongful convictions, and I think that people have the right motives. And there's been a lot of changes put in place by various states' attorneys' offices. But one thing that I've noticed is a lot of the changes look backwards. I'm going to look at the previous state's attorney and see what that state's attorney did and review all of that state's attorney's convictions and make sure that they're good because we want justice. What I haven't seen a lot of, and I'm hoping to see more of, and I'm talking with state's attorneys about this, is the reforms I have look forward. How are we going to stop this from happening again? And that's where I'm hoping to have the support, because it's not enough just to look at the past and say this happened in the past, it's not going to happen again. I mean, that's great, that's good reforms, we need it, but we also need to have reforms that are going to stop it in the future, and no one is above this. And so I would hope that every state's attorney in the state would be on board with wanting real criminal justice reform. Now, the last reform I'll talk about quickly It's called it deals with the post-conviction procedures. If someone has been convicted wrongfully, what do we do? The process used to only be open to people who are inside the penitentiary, and it was very limited. I proposed a bill that got out of the House a couple weeks ago that would open this up to anyone who had been in prison or in detention and can prove or has evidence of actual innocence, that they would have access to this post-conviction procedure. And some people said it was too broad, and originally I thought maybe it was, but as I thought about it, if you had evidence that you were actually innocent, why should it matter when you had that evidence and where you were in life? You should be able to bring your claim. And was able to convince a majority of the people in the House of Representatives that this was a good reform that is now sitting in the Senate, and we're hoping that that will get through the Senate and become law. So again, those are reforms that I'm working on. There was a full-page article in the Tribune about all of this today, so it's very timely that I'm speaking here. Just the fact that you're all here, I think, is great for criminal justice because people need to be interested in this. It's important. I'm certainly always going to continue championing these issues, and look forward to hearing some of the discussion today. But thank you again, and thank you to the League.
Thank you, Scott. Next, I would like to introduce you to our state's attorney here in Lake County. Winning election this past November to become Lake County state's attorney through a campaign that promised to address issues of wrongful convictions in the county in the wake of some high-profile cases, such as the Juan Rivera case. Mike Nierheim has already created a case review board of individuals who are sworn in as special assistant state's attorneys, separate from the state's attorney's office. The duty of this independent review board is to review cases which have triggered questions regarding DNA. State's Attorney Nierheim came to the office as an already experienced prosecutor, working as an assistant state's attorney and later as a defense attorney, looking at prosecutions from both sides of the case. He was appointed by the courts also to investigate post-conviction issues pursuant to the Illinois post-conviction laws. He has also defended the rights of individual defendants by writing and arguing post-conviction petitions. He is also involved in the community. He serves as teen court judge in Warren Township, and he is an advisory member of the Staben House and vice chairman of the Lake County Bar Foundation, which has gladly afforded me the opportunity to get to know Mike. Mike is also on the board of directors of NICASA, Lake County Crime Stoppers, former Inmates Striving Together, called FIST, F-I-S-T, and Lake County Sexual Assault Council, also the Lake County Underage Drinking and Drug Prevention Task Force, and is the chairman of the Lake County Domestic Violence Coordinating Council. I'm going to invite Mike to come up and speak to us a little bit about what's going on in the county. Terms of.
Thank you. Well, thank you, and thank you for being here today. And I came into the office of state's attorney in Lake County about almost exactly 4 months ago, a little longer. And when I took over the office, there were a lot of issues that I know all of you are aware of, which is why I think most of you are here today. And the issue becomes, what do you do about it? And I could have come into office, I suppose, and said, well, these things happened under the prior administration and it's a new day and we're not going to let that happen again. I chose not to do that. I chose to take a very serious look at this issue and try and come up with ways on preventing wrongful convictions from happening in the future in Lake County. We simply can't afford one wrongful conviction. And the fact that Lake County has become known, I think, nationally as the wrongful conviction central. When there's a discussion in Colorado about wrongful convictions, Lake County, Illinois is part of that discussion, and we just simply can't have that. When that happens, our entire criminal justice system has failed. What I did, because I didn't want to wait for anything, I wanted to get involved in this right away, and I wanted to take a serious look at Lake County as a whole. I invited various professionals from around, not Lake County actually, most people on my panel are not from Lake County, some are. But I asked people, experienced professionals from outside of the state's attorney's office, retired judges, defense attorneys, prosecutors from other counties, people from, again, different backgrounds. We have an investigator. These people volunteer their time, and they come and they sit with me, and we meet periodically, and we talk about a couple of things. One, we talk in general, and what protocols can we put into place right now. And legislation is great, and I'll work with Representative Drury on legislation. That's great. And there are things, though, that we can do right now. There are things that I can do working with chiefs of police around Lake County to put protocols into place within my office and also with them to ensure that these cases don't happen again. So we look at wrongful convictions as a whole. DNA has been the subject of a lot of discussion, but DNA is not certainly the only issue we see when it comes to wrongful convictions. We see oftentimes faulty identification or issues with regard to the interrogation procedures. So in putting this panel together, we've come up with some protocols that we're going to move forward with the Chiefs of Police Association in Lake County and with me in my office. And there are, again, things we can do right here in Lake County. The second thing that we've done as a panel in Lake County is we have looked at some cases that have been brought to my attention that we're currently looking at. The subject of the media has predominantly been about 4 cases, but there are other cases that individuals have brought to my attention that again, we are taking a very serious look at. And this panel, I think, is so important because it gets to the root of, I think, one of the major causes of wrongful convictions, which is this cognitive bias or tunnel vision, where prosecutors or law enforcement, they look at a certain set of facts and they truly believe in their heart that it happened a certain way, and they tend to look at evidence that fits their theory a little bit closer than maybe other evidence. And it could be that other piece of evidence that could show that God forbid, you have the wrong person. It's very difficult when you've invested a lot of time or when you work in an office really as small as Lake County. There are 74 prosecutors in my office, and that's a pretty good size office compared to the rest of the state, but it's really not that big in terms of everybody sort of socializes together. It's kind of like a big family. So when one prosecutor is called upon to look at another prosecutor's work objectively, it's hard to do because, again, these are people that work together every day, and you want to think that your coworker got it right. So this panel, I think, can pierce through that because, again, these are individuals that really have no ties to Lake County, have no ties to these cases, have a very diverse background in terms of experience, and no dog in the hunt, so to speak. I mean, they look at the case for the first time with a fresh set of eyes, and they may pick out a piece of evidence that is critical that nobody looked at before. So that's just one of the things we're doing in Lake County. Another thing that I've done very recently is really beefed up the experience level of the prosecutors that work in our felony review division. Felony review, for those of you that don't know, is essentially the gateway into the criminal justice system in Lake County. Every felony case, every domestic case, when the police make an arrest or they want to get a warrant or they want to work on a case a little further, they have to call into our felony review division, and the prosecutors there work with the police, and at that point they can say, I don't believe you have enough evidence to charge this person. It's a very, very important division in my office. I think it's probably the most important division in my office because if we have a case where, again, we don't have the right person or the evidence doesn't suggest we have the right person, it's very critical that at that point a prosecutor has the courage to basically say no. And I've worked in that division when I was a young prosecutor. I know from experience it can be difficult. But I think where the office has failed in the past is that's in the stepping stone of one's career in the state's attorney's office. It was on one of the first couple of steps. You essentially went to law school, you graduated law school, and then you went into the traffic division, and then the misdemeanor division, and then felony review. You've never tried a felony case. You've never probably tried a jury trial involving a felony case, even a minor felony case, and yet you're called upon to make really the most important decisions in the office, whether cases get charged or not. So we've flip-flopped that and put some of the more experienced people in the office in that division, and I think that's going to do a lot, certainly in Lake County, to ensure the cases aren't getting into our court system that shouldn't. So I don't want to take up too much time here today because I really did come today to listen, to learn. The issue of wrongful conviction as it relates to women is, I have to admit, something I hadn't thought about before, and I'm excited to learn today, so just as much as you are. So with that, I'll stop talking, and I'll stick around for questions afterwards if anybody has questions for me. But thank you for being here.
Women fighting wrongful convictions face special challenges. Often they were convicted of harming people close to them, meaning they had to deal with deep personal loss, while at the same time defending against criminal charges. Women are viewed as society's caregivers, so women charged with heinous crimes, murder, arson, or sexual abuse are particularly reviled. There is typically no DNA evidence in cases with female defendants, making their conviction harder to overturn. Natural or accidental deaths can be mistaken for murder, and indeed, according to the National Registry of Exonerations, over half of female exonerees were convicted of what turned out to be no crime at all. The newly formed Women's Project of the Center on Wrongful Convictions is beginning to study the special factors contributing to wrongful convictions of women. This afternoon, our guests will explain how and why they formed the Women's Project, and will present data on women's wrongful convictions as well as specific case studies, including lessons learned from representing female clients of the Center on Wrongful Convictions. I want to introduce our panelists today. Karen L. Daniels joined Northwestern University's esteemed Center on Wrongful Convictions as a senior staff attorney in the fall of 2000. Ms. Daniel is a graduate of Harvard Law School and a former member of the Illinois Office of the State Appellate Defender. During her tenure at Northwestern, Ms. Daniels has successfully represented clients in state and federal court proceedings and before the Illinois Prisoner Review Board, achieving numerous exonerations in both DNA and non-DNA cases. She also serves as clinical professor of law and teaches second and third year students. Most recently, she conceived and co-founded the Women's Project of the Center on Wrongful Convictions. Our other panelist is Judy Royal, who has been part of the Center on Wrongful Convictions since 2001. She is a graduate of Northwestern University School of Law. Ms. Royal has been involved in the Center's public education efforts as well as assisting in the representation of Center clients Julia Ray, who was acquitted of murder after a retrial in 2006. Maurice Patterson, who was freed in 2010 after prosecutors dropped murder charges against him in the face of evidence pointing to another suspect. And Jacques Rivera, who was granted a new trial in 2011, and the Cook County State's Attorney's Office chose not to pursue the case, and Juan Rivera, whose conviction was reversed in 2011, and the Lake County State's Attorney decided to not appeal the appellate court's outright reversal. Her involvement in Julie Ray's case led to her role as one of the founders of the Women's Project of the Center on Wrongful Convictions. And our third panelist is Erin Topp, who is a clinical fellow at Northwestern University's Center on Wrongful Convictions. Her year-long position at the center is sponsored by Kattenmuchen Rosenman, LLP, a Chicago law firm, where she will begin as a litigation associate in September of 2013. Ms. Topp is a recent graduate of the University of Virginia School of Law, where she first developed a passion for innocence work. As a student at UVA's Innocence Project Clinic, directed by Deidre Enright and Matthew Engel, she studied the causes of wrongful convictions and helped to challenge a wrongful murder conviction in Albemarle County, Virginia. Prior to law school, Ms. Topp graduated from the University of Notre Dame in 2007 with a BA in Political Science and Peace Studies. She also received a Master's of Theological Studies from Harvard Divinity School in 2009, where she studied the role of religion in the political sphere. Please join me in welcoming our three distinguished panelists.
Well, thank you for that very lovely introduction. In case you didn't know who was who, I'm Karen Daniel, Judy Royal, and Erin Topp. And I really want to thank the League of Women Voters for putting this together and for this opportunity, and especially Sally Zeit and Linda Bartmus for organizing this event. And I'm also very gratified that State Representative Scott Drury and State's Attorney Mike Nierheim were able to come by and make some remarks and be part of this as well. Those of us who work on wrongful conviction cases a lot are so gratified that some of our elected officials have taken up these issues, and these two gentlemen have only been in office since the beginning of the year, and they already are making great strides in reducing the incidence of wrongful convictions. And I often tell people that I think that those of us at the center have as much or more in common with the prosecutorial community as we do with the defense community, because when we look for cases of innocence, we are simultaneously looking for the true perpetrators who may have gotten away, and that's an interest we have in common with prosecutors. So what I'm going to do is I'm going to begin by giving a little background first about the Center on Wrongful Convictions itself, in case some of you are not completely familiar with it, and then move into introducing our Women's Project and tell you a little bit about why we started it. And I'll be followed by Aaron and Judy, who will talk about some of the data that we've collected on women's wrongful conviction cases and some of the major causes of these wrongful convictions. So here we go. So the Center on Wrongful Convictions was founded following a 1998 national conference on innocence and the death penalty. And I know we talk a lot about wrongful convictions now, people are familiar with this concept, but only 15 years ago, a lot of people really couldn't fathom that an innocent person could not only be convicted of a serious crime, but also could be sentenced to death for that crime. So my mentor in this work, Professor Larry Marshall, who at that time was at Northwestern, he's gone on to sunnier climes, he's at Stanford now, but he conceived of this conference, and he brought together on one stage 31 individuals who had at one time been on death row, whose cases had been thrown out, and who had compelling claims of innocence. And visually and emotionally, seeing all those people together, and they were less than half of the known death row exonerations at that time, but seeing them all together really started a change in thinking on the part of many legal professionals about whether wrongful convictions were a rarity or whether there really were some systemic problems that needed to be addressed and studied. And of course, we at Northwestern fell into the latter camp, and thus the Center on Wrongful Convictions was born. So this November, actually, we will celebrate the 15th anniversary of that conference. And since the center's inception, we've been instrumental in the exoneration of 36 men and women in Illinois. We're also, or I'm also especially proud of the fact that we were one of the first innocence projects in a law school that was willing to take on non-DNA cases as well as DNA cases. And as State's Attorney Nierheim pointed out, the types of issues that arise in DNA cases, mistaken identifications, false confessions, faulty science, sometimes witnesses who commit perjury. When there's ultimately DNA evidence at the end of the case to tell you, oh, this is definitely the wrong person, it's easy to accept that these factors took place in the case. But we have to remember that most cases don't have DNA evidence of any kind, and yet the same things can happen in the other cases, the other 90% of the cases. And so we really pride ourselves in taking on the harder cases, the ones without DNA, and trying to work through those as well. Some of the other things that we've accomplished since the center was founded have included advocating for certain reforms in the criminal justice system. Some of them have included electronic recording of police interrogations in homicide cases, and as you just heard, Representative Drury is advocating that that be expanded to other felony cases, and we're very much in favor of that. Obviously, abolition of the death penalty in Illinois, we were very much involved in that effort. And then something special that Illinois has that most states don't have is the certificate of innocence option for a person whose conviction has been set aside. If a person was convicted and on a second trial they got an acquittal or the charges were dismissed, that doesn't always mean that they're innocent. But if they really were innocent, it's nice to have a vehicle to establish that and have a court certify that so that they can go on with their lives without a cloud hanging over their head. And so that was a piece of legislation that passed in 2008 that we're really happy with in Illinois. So as we've moved along, litigating cases, advocating for reforms, we've also started to think about the fact that different factors that are involved in wrongful convictions can affect different populations of individuals in different proportions. So one example of that is youthful suspects and persons who were convicted of crimes when they were juveniles, when they were teenagers. In 2009, we started a youth project. And that project has focused primarily on looking at police interrogation tactics as applied to young people. And what they've learned through their research and the cases they've worked on is that young people are more vulnerable than adults to police interrogation tactics. And as a result, they can be more likely to confess falsely to something they didn't do when the same tactics used on adults are applied to them. And so the folks at the center who've been working on that project have done a lot of work, public education and educating police officer associations on other ways of interrogating juveniles that can result in more reliable statements by the juveniles. So following that, we began to look at our women's cases. Since our inception, we have represented 4 women in court litigation, and that's not very many. It's a small percentage of the people that we've represented overall. But there are just some striking similarities in these cases, which you can see up there. All 4 of these women were moms who were convicted of killing a son or a daughter. And these were not babies who died. These children ranged in age from 3 to 10 in these 4 women's cases. None of these women had any background that would make you think she'd be likely to harm her child. None of these women had psychiatric illnesses. They did not have prior histories of abuse of their children. They did not have any motive to harm their child that you could point to. And yet they were all convicted of killing their child. And something else we noticed about the cases as well was that in each of these cases, the police interrogated these women while they were still in shock from their child having just died, while they were grieving, and in one way or another, the statements that these women made to police in that horrible period of time right after their child died, their statements were used against them at trial to gain their conviction. Not every women's wrongful conviction case falls into this pattern, and certainly there are men who are wrongfully convicted of killing their children. But it just so happened that in our cases, we didn't have any men who fit this pattern, and we had all 4 of our women who followed this pattern. And so we thought this probably isn't a coincidence. This is probably something that we should look at a little more carefully. So the Center on Wrongful Convictions Women's Project was born. We launched last November. And what our objective is at this point we have more questions than answers. We want to look at whether there needs to be more research into this area, and we want to think about whether when we screen cases, we should be looking at women accused of killing their children or another loved one, perhaps a husband or a parent, or perhaps a daycare worker who's convicted of harming a child in her care, whether we need to look at these cases through a little bit of a different lens than perhaps we had been before. And also just to get past the tremendous emotion and emotional response that you feel when you look at a case of a child who's died, because that is very difficult for everyone concerned to get through. So what we're going to do here today is we're going to, again, as I said, present our opening data. But before I hand over the mic to Erin, I really do want to talk about my first female client, Julie Ray. And I want to point out that her case, it's what I call a completed case, in the sense that she was convicted, she went to prison, she was retried and acquitted, and then she was able to take advantage of the Certificate of Innocence legislation. She has, in fact, been declared innocent, actually innocent, by the state of Illinois. And I just want to tell you a little bit about her case, because it's very near and dear to my heart. Julie was a mom. She was also a doctoral student at the University of Indiana at Bloomington, and she was a divorced mom. Her ex-husband was remarried and lived in another county in central Illinois, but they shared custody of Joel. So when Julie had Joel, when she didn't have Joel, she would be studying in Bloomington, but when she had Joel, she lived with him in a small and cute little house that they had in Lawrenceville, Illinois, which is a very small town near the Indiana border. And her parents, Julie's parents, also lived in town. Her dad was a minister, and Joel was the only grandchild and was Julie's only child. So as you might imagine, he was very doted upon when he was living with Julie, and they all took care of him and they all loved him. But everything changed on October 13th of 1997. And on that day, Joel was at Julie's house, and they woke up, or Julie woke up in the early morning hours. It was still dark out. She heard a noise. She didn't know what it was because she had just awakened. But she got up out of bed to check on Joel, whose bedroom was across the hall from hers. And she went out into the bedroom, and she could see into his room, and his bed was empty. She didn't see him there. And before she could really process that, a man basically leapt at her from that area, and they kind of had a small scuffle right there, and she was kind of grabbing on him. She really didn't know what was going on. She was dragged along a bit, down her hallway. She got some rug burns on her knees. She was just wearing a little nightshirt, and he went barreling out through her house with Julie in pursuit. He crashed through her door that led to her garage. It had a glass pane in it, which shattered when he slammed it open. She pursued him out into her large backyard area, and this is a rural area of the state, so it's one of those. It was one of those housing developments that had houses kind of in a square, but all the backyards were sort of all connected, so there was a lot of space out there. And she caught up with him out there, and they fought some more, and he was bigger and stronger than her, and he hit her, blacked her eye, and beat her head into the ground, and she finally let go, and she was a bit in a daze. And he took off a mask he'd been wearing, or possibly a ski mask, and he basically walked off into the night. So Julie ran across the street in front of her house to a neighbor's house and called the police for help, and she thought her son had been kidnapped, which is what she told the police because she hadn't seen him in her bed, or in his bed. So the police responded, and they went into the house. They went in. There was some fear that perhaps there was still an offender in the house. And what they discovered, to everyone's absolute horror, was that, in fact, little Joel was in his bedroom, but his body had fallen off the back of the bed. He'd been stabbed, and his body was not visible from the hallway. He had fallen between the bed and the back wall of his bedroom. He was lying in a pool of blood, and by that time he was dead. And the police immediately fanned out around the little neighborhood and did not find the man that Julie had described. And at that moment, and from that point forward, Julie was the only suspect that they ever considered in the murder of Joel Kirkpatrick. She, of course, being the parent, cooperated as fully as she could in the police investigation, and this meant that she was subjected to numerous police interrogations, which were recorded, which was a good thing. They were audio recorded at that time, which wasn't required, but it was something that they did, and that was good. And the interrogations got progressively more accusatorial. At one point, the police lied to her, which is a legal police tactic, but it is not always the most, it's not always the tactic that brings forward the most reliable statements. They told her that there had been aerial photographs taken above her home at the time of her son's murder, and they said that those photographs had not shown a person leaving in the direction that she said this guy had run off in, and this confused her because she remembered what she remembered, but she began to doubt her own story, and she said, well, maybe I'm wrong. Maybe I'm wrong about the time, or let me think about this. And she never said she did it. I mean, she always denied having anything to do with it. She always said another man had did it, but her statements began to be a little questionable, a little tentative, perhaps a little inconsistent, and that was used against her at her trial. At her trial, she had an appointed attorney, one attorney with few resources, and he really was not able to properly challenge the state's case, which really was, for the most part, as the prosecutor summed it up at trial, Julie and Joel went to bed that night. They were the only two people in the house. Joel was murdered. Julie was the only person there when everybody else got there. She must have done it. They also brought in the fact that there was no sign of forced entry to the house. Neighbors came out of the woodwork to talk about Julie. They said that she acted a little odd after the murder. They said that she acted self-absorbed. There was just a lot of judgmental opining on her affect afterwards. And one thing that is definitely clear that anybody who works with these types of cases knows that there's no one way to react to a trauma of this nature. But that's not what the jury was told. The jury was told that her reactions were inconsistent with her being a grieving mother, and so that was used to convict her. And she went to prison in 2004, and she wrote to the center to take her case. And it was a hard case to review. At the time that we eventually took the case, I had a son around the same age as Joel was when he died. The photographs are horrible. It's just emotional for everybody. Believe me, I'm not the most aggrieved individual, but it teaches me that these cases often don't get taken up because they're just so hard. They're just so hard to work on. But one thing that emerged after trial was some new evidence, some totally new evidence, and that was that there was a serial killer who, I'm actually going to go to the next slide here, this is Julie today, a serial killer who is still on death row in Texas who actually ended up confessing to this crime. And he confessed to it in some detail, and he said that he had killed Joel as part of a multi-state killing spree that he was on around that time and in that area. And so we took a second look at the case. Judy here was really the instigator of us taking another look at it and ultimately taking up the case. And we began to prepare to bring this new evidence to court and try to get her conviction reversed for that reason. But we were really very lucky in that her appeal, which we weren't even involved with, just her regular appeal from her conviction, was successful on a very technical legal ground, and she was granted a new trial for reasons not having to do with the evidence in the case, and I won't go into what that was, but it did give her the opportunity to have a second trial. The second trial was completely different than the first trial. We had a bigger team. We stayed with the case, and we involved a large law firm in Chicago named Schiff Hardin LLP, and its managing partner is another assistant United States attorney named Ron Safer, who came on board and basically led the trial effort. And because we had more resources, we had a big team, we had lots of eager law students, we were able to mount a very different defense to the charges the second time around. And through expert testimony, we were basically able to establish that there was another person in the home that morning. I won't go into every detail of that, but I'll give you a couple of examples. One was that Julie's nightshirt had a lot of her own blood on it, because when the door with the glass pane was broken, she got cut, so she was kind of covered in her own blood, but also there were a couple small spots of Joel's blood, which at the first trial was used as evidence against her. It was characterized as an indication that she'd stabbed him and the blood had splashed back on her, even though one of the spots was on her back. But at the second trial, actually the state's own blood stain expert explained that these stains were actually transfer stains that don't arise from splashing, but rather from rubbing up against something with blood on it, which was very consistent with her having struggled with her son's actual killer, who probably was pretty bloody after what he had done. There was a police officer who was one of the first responders who testified at the first trial that there was dew all over the grass in the back of the house, and that he specifically looked for footsteps in the dew, and there were none, and that convinced him that there was no person that had run off through the back, like Julie said. We thought to consult with a meteorologist, and he checked the weather data at that time in that location, and he testified at the second trial that, in fact, it was impossible for dew to have formed at that time on that day. And so what the police officer remembered, and he hadn't remembered this until about a month after the fact, was couldn't have actually happened. And then, of course, we brought out the evidence of the serial killer and his confession. But not only his confession, we also presented witnesses who had seen a man fitting the description of the person that Julie had described in the area of Lawrenceville, both before and after the crime. And in fact, one of the witnesses who had seen this man, he was a gentleman, he had seen a very menacing man in a Lawrenceville diner very shortly before the crime. And once he heard about the murder of Joel on the news, he contacted the police and he tried to get them to look into this because he thought this could have been Joel's killer. And by that time, the police were so focused on Julie that they just did not follow this very promising lead. So those were some of the factors that ultimately resulted in Julie's acquittal. And that was in 2006, and as I said, she was able to get a certification of innocence after that. So that case has been very formative for me. Personally, Julie has stayed very involved with the center, and she has pretty much, over the years, begged us, insisted, demanded that we start a women's project because Julie believes that not only are there certain types of cases that affect women more than men, such as these, what I call situational cases, where the woman is the caregiver, something happens to the child, so the woman is the one that is being looked at first. But also, Julie feels that women experience injustice in the criminal justice system differently. They experience incarceration differently, and they heal differently. And she felt there really needed to be a place where women, such as herself, could network with professionals working on their cases and with each other in order to heal. So the Women's Project is a testament to Julie and to Joel. And if I could name it the Julie Ray Women's Project, I would, but I think my dean is probably hoping that some generous benefactor will come along and it'll be called the Jane Doe Women's Project. But that's Julie really, I think, is the main instigator of our project. But now I'd like to hand the floor over to Erin, who's going to talk a little bit about some of the data that we've put together at the outset about women and wrongful convictions.
Hi, thank you. As Karen explained, the 4 women clients of the Center on Wrongful Convictions had some noticeable patterns and similarities. But when we started the Women's Project, we wanted to look at actual data and see what do we know and what can we find out about women's cases of wrongful conviction, and are there, in fact, causes that that affect women's cases much more than in men's cases. And thankfully, thanks to the Northwestern's Center on Wrongful Convictions and the University of Michigan Law School, they launched a project called the National Registry of Exonerations, which is a public database of every known exoneration in the United States since 1989. And it's accessible to everyone here. You can search every, oh, I keep forgetting to actually change the slide. There we go. Thank you. So this is an example of a screenshot of the National Registry of Exonerations where I have gotten the data that I will be presenting to you today, and I just encourage you to go to the website on your own time and look through. As you can see, to date, there are 1,102 known exonerations in the United States since 1989, and the number keeps growing, both because people are being exonerated newly each day, but also exonerations from the past are being reported to the registry, and they're adding exonerations as they come to learn of them. And it organizes the exonerations by factors and causes, dates, types of crimes, so it's very helpful. And it's been helpful to us at the Women's Project to sort through the women's cases and see what's happening in the wrongful convictions of women, and to see if we can identify certain causes and factors in women's cases. The first very striking piece of data is out of the 1,102 exonerations in the registry, only 79 of the cases are women. That's only 7% of all known exonerations in the United States are women's cases. So clearly, women are being exonerated, under-exonerated as compared to men. It is true that women are convicted and incarcerated at much lower rates than men, but it is not at a 7% low rate. One statistic that we can compare this to is counting the number of felony convictions in state courts across the United States. 17% of those convictions are of women. So that gives you a rough idea that the numbers should be a little bit closer to 17 or 20% and not the 7%. So one of the first striking features is that women are being under-exonerated. But I should also say that because we have such a small sample size of women, when I present these statistics, I want to be clear that they're more descriptive than predictive. We do have a small sample size, so when I present a percentage of women's exonerations, those numbers could change slightly as we get more information, more exonerations. But we do have numbers now that can start raising questions. So rather than presenting these statistics as research, we hope to present them as what we see happening now and what questions do they raise, and inviting research rather than presenting this as the research. According to an annual report this past year by the registry itself, the types of crimes that these innocent men and women were wrongfully convicted of tend to be very different. On the second line, you'll see sexual assault cases. That's a very noticeable difference that affects 23% of wrongfully convicted men and almost none of the women's cases. And this translates into our first statistic, is that DNA rarely plays a role in women's exonerations. The types of cases that women are wrongfully convicted of don't lend themselves to DNA evidence, like a sexual assault or a homicide. Sometimes it can, sometimes there is testable evidence from their original trial that can lead to their exoneration. But as you can see, it's only playing a role in 9% of known women's exonerations, while it plays a role in 33% of men's cases. Another very striking statistic about, is that among all women's exonerations now in the registry, did I not? There we go. 63% of those cases were convictions for crimes that were actually not crimes at all. For instance, if it was a death, it wasn't the result of a murder, it was the result of an accident or another natural cause that was wrongfully identified as being a crime, and then they found out later. And so this is the case in 63% of women's cases and only 16% of men's. So we try to look at what's going on here. Part of the problem is that in the 1980s and 90s, there was a wave of prosecutions across the United States based on questionable allegations by children that they were sexually assaulted. And these mounted huge prosecutions involving very questionable interrogation tactics of children who are very easily manipulated and fed information that translated into accusations against hundreds of people during this time. Pastors, parents, uncles, daycare workers were affected in rings of prosecutions. So 24 of the 50 women's cases in which no crime occurred in their original conviction, 24 of those were the child sex abuse cases that I'm referring to, which clearly inflates the stats. 30% of all the women exonerees with a no crime case were these child sex abuse hysteria cases. But only 26 cases of the men's exonerations, which is only 2.5% of the 1,000 male exonerations. So while child sex abuse hysteria in the 80s and 90s seemed to affect men and women equally, and they've now been exonerated at equal rates, this clearly affects the women's data. But even when we remove the child sex abuse hysteria cases and try to look at cases that were convicted, crimes of, that women were convicted of and then exonerated where no crime actually occurred, it's still 33% of women's cases compared to only 13%. Other common causes of wrongful conviction, when we compare men and women, we do see a difference, sometimes slight, but sometimes very striking. For instance, false confessions occur in 12.6 of the men's cases, but in 19% of the women's cases. Official misconduct, there's a slight difference. It's too early to know yet if this will pan out, but it occurs in 44% of men's cases and only 40% of women's. And then false or misleading forensic evidence played a role in wrongfully convicting 35% of the women as compared to only 21% of the men's cases. And when we take a closer look at the false or misleading forensic evidence in women's cases, which clearly plays a very big role in wrongfully convicting women, we can see that some of the science in these cases is quite complicated. Shaken baby syndrome diagnosis, arson science, sexual abuse science, toxicology, all these things were either false at the time or misleading and wrongfully led to their convictions. So undoing women's convictions based on science can often be quite technical and require a lot of expert evidence to undo the convictions. Another striking feature of women's exonerations is that women are convicted of crimes against children at a much higher rate than men. According to the National Registry of Exonerations, their 2012 annual report, 52.1% of female exonerees were convicted of crimes of violence against children compared to only 17.6% of male exonerees. So we're clearly seeing a problem that women, more often playing the role of a caretaker of children in our society, their opportunity to commit crimes against children is translating into their being convicted of those types of crimes at a much higher rate. Lastly, a notable statistic that comes from reading all 79 cases of wrongfully convicted women in the database is that 22.8% of the women were convicted of harming or killing a loved one, such as a family member, a child, a husband, a mother, someone close to them in their family. And as Karen indicated in Julie Ray's case, this is happening in the wrongful convictions of many women, 22.8% that we now know. So when women are experiencing the trauma of trying to defend in a criminal case and then being wrongfully convicted of that crime, have the second layer of trauma of having to deal with that while dealing with the loss of a loved one in many of these cases, which, as Karen indicated, is not only difficult for the client, but difficult for the lawyers and the teams being involved in these types of cases and trying to undo these convictions. The last thing I wanted to present to you is not the numbers that come from the registry, but perhaps patterns that we're noticing as we read more and more cases of the wrongful convictions of women. Sexism and gender bias plays a pretty prominent role, and we're seeing very common ways in which sexism creeps up in trials and is used against women, but also how it plays a role in investigations. And we also want to clarify that gender bias and prejudicial evidence is used against all defendants, or many defendants, both men and women. But we've noticed interesting cases of sexism in the women's cases that we wanted to bring to your attention. My first example, thank you. My first example is Cynthia Summer out of California. She was a mother of 4 children in California, happily married to her husband who was in the military, and he was only about 23 years old, I believe, and suddenly died in 2002. And as they were investigating the case, they produced lab results that showed that he was poisoned by arsenic. She immediately became the suspect and was charged and convicted 3 years later. I won't go into all the details of her case and then her later exoneration, but I wanted to bring to your attention that her defense lawyer made a pretty strategic mistake during her trial. The judge had ruled that the prosecution wasn't allowed to present evidence of how she grieved or her acts and behavior after the death. But because her defense attorney presented evidence of her loving nature and that she did in fact grieve for her husband, it opened the door for the prosecution to come back with pretty damning and sexist evidence in return. So first, they talked about in her trial that she didn't grieve appropriately. They brought many cases of her having sexual relations too soon, according to the prosecution, for someone who would be truly grieving their husband, the death of their husband. They brought in evidence that she entered a wet t-shirt contest within a few months of his death. And then finally, they had the motive evidence that she wanted to get breast augmentation surgery, which is why she wanted the $250,000 life insurance policy that she would get from his death. And thankfully, the labs showing arsenic were proven faulty later. She was granted a new trial, and she was exonerated. But you can see that that really inflammatory evidence used against her was a big cause of the jury convicting her in the first place. Another example is Jennifer Hall out of Missouri. She was convicted. She was a respiratory therapist. And while she was at work, a fire started in one of the respiratory therapy rooms in January 2001. And she ran back in to try to put out the fire and ended up burning her hand. And the investigators believe that the burns were actually caused by her starting the fire. And at trial, they said she had 2 motives. The first was to gain attention. They actually presented at trial the evidence that she wore her hair curly on the day of the fire instead of wearing it straight like she normally did, because she knew she would be in the limelight in her heroic attempts to put out the fire. So that was used as evidence against her. They also said that she was angry at a coworker who she filed a sexual harassment claim against, but before it was resolved, he ended up dying. So I suppose the fire was supposed to be some sort of angry vindication against this coworker, who she never got justice against. She was later granted a new trial for ineffective assistance of counsel for failure to investigate other possible causes of the fire, because the minute her new defense attorney looked at the evidence, it was strikingly clear that it was caused by an electrical shortage and bad wiring, and that it wasn't arson in the first place. And she was retried and then acquitted in February of 2005. And lastly, this has been hit on a little bit just through the story of Julie Ray's case by Karen, but gender bias can come in the investigation, and it can play a role in why women become suspects of crimes that they didn't commit in the first place. Police investigators and prosecutors often have a notion of what they expect people who are grieving or people who are experiencing trauma, what their behavior should be like. And if a woman deviates from that, it's used as a sign of guilt. So often, if women act too sad, it's seen as fake and theatrical, so it's not true. But then if she's not sad enough, then she's not grieving properly, so she must have done it. And the questioning of women who are experiencing a trauma during a police investigation is often during a time of shock, as Karen explained. So their statements are often hazy, confused, and those are used against them as inconsistent statements and evidence of guilt. And finally, often the role that women tend to play in our society as caregivers, as mothers, often leads to the improper zeroing in on female suspects as the sole suspect in a case where it doesn't quite make sense. For instance, in Patricia Stallings' case, she was convicted of poisoning her infant son with antifreeze. Her son, it was later discovered, ended up dying of a rare genetic disorder that leads to false positives of antifreeze from the compound in antifreeze in her labs. But she was convicted and not her husband, because she was the one who supposedly fed him more, so would have more opportunity to poison the bottle. And that's why the investigation zeroed in on her in the first place. And finally, Letha Jean Hockersmith out of Oklahoma, she took her 2-year-old adopted daughter to the hospital because she had fallen 2 days before and was acting funny and showing strange signs. And she ended up dying 3 weeks later from complications. The medical examiner who reviewed the autopsy determined it showed signs of shaking and blunt force trauma to the head. So they concluded that the 2-year-old must have been beaten or shaken, and that's what really caused the death. But instead of investigating both Letha Jean and her husband, who had equal opportunity to have done that to a child, they focused strictly on Letha Jean, and she was wrongfully convicted, and thankfully was later exonerated in 1996. So those are just some of the few examples of the patterns we see sexism, gender bias investigations playing a role in women's wrongful convictions. And now I'll turn over the presentation to Judy Royal.
Thank you. There's a lot of research out there about interrogation practices and false confessions, but not specifically on whether women respond differently to police interrogation than men, especially when they are in shock over a child's death. There's something known as the Reed Manual. The actual full title, as you can see, is Criminal Interrogation and Confessions. And this is used to train police personnel throughout America and actually around the world in the Reed technique in interrogations. Now, I'm not criticizing the Reed technique. Actually, Fred Inbau, one of the authors, was one of my favorite professors, and I think the world of him. And this is an extremely effective technique in obtaining confessions. The problem is that sometimes it may accidentally result in a false confession. I'm going to read you something from the Reed Manual about the steps of an interrogation. The innocent suspect's face may become flushed. The eyes may concentrate on the investigator, and he may also respond verbally in an angry, blunt manner. A guilty person will usually be passive. He may respond with a rather pleading look and answer in the form of a soft denial or a rather vague inquiry to the investigator. A guilty suspect may attempt to evade detection by employing dramatic physical gestures, moving the head back and forth and running their fingers through their hair in an effort to create the impression of complete desperation. Now, I think you don't need to be an attorney or a police officer to hear that and think, well, maybe a woman being questioned might not be angry and blunt, especially when they're grieving and in shock over the loss of someone that they love. One of our missions, as Karen and Aaron have already mentioned, is to promote and encourage research in areas involving women. And this seems like certainly one that calls out for scholarly inquiry. As Aaron mentioned earlier, over 19% of female exonerees falsely confessed to a crime. Now, if this number included inculpatory statements, and by that I mean a statement that is not a confession, but somehow ends up being used against the defendant, it would be much higher. I'm going to discuss 3 cases. One from Chicago, affectionately known by some as the false confession capital of the country, and 2 from different states, one of which resulted in a death sentence for a teenage girl. Nicole Harris was convicted in 2005 of murdering her 4-year-old son, Jakari, who died of asphyxiation, strangled with an elastic band from a fitted bedsheet in a bedroom he shared with his 5-year-old brother, Deontay, in the family's home in Chicago. Deontay told investigators that he had seen Jakari wrap the band around his own neck while playing Spider-Man, and that neither his mother nor father were present. The medical examiner ruled the death accidental. Meanwhile, Chicago police interrogated Nicole, who was a 23-year-old graduate of Southern Illinois University. After 27 hours of intermittent grilling, Nicole confessed to strangling Jakari. The medical examiner then changed the official cause of death to homicide, and Nicole was charged with first-degree murder. At a pretrial hearing, the judge held that Deontay was not competent to testify because he believed in Santa Claus and the Tooth Fairy, not unusual in a child his age. Without Deontay's testimony, however, the jury found Nicole guilty based on her confession. Before her sentencing, Nicole wrote to the Center on Wrongful Convictions, who, along with some pro bono attorneys, wrote a motion for a new trial. The judge denied the motion and sentenced Nicole to 30 years in prison. In October 2012, however, the U.S. Court of Appeals for the Seventh Circuit granted the writ of habeas corpus, holding that the exclusion of Deontay's testimony violated Nicole's right to present a meaningful defense. Prosecutors have appealed the Seventh Circuit's decision to the U.S. Supreme Court and may be planning to bring Nicole to trial a second time. In the meantime, Nicole is trying to rebuild her life and spending time with her son Deontay, who was 5 years old at the time of his brother's death and is now a teenager. Beverly Monroe. I don't have a slide for Beverly, but I'm going to tell you about her case anyways. Beverly Monroe had a master's degree in chemistry and was working as a patent analyst. Her companion of 13 years, Roger Zygmunt de la Bourdais, lived outside Richmond, Virginia. After having dinner together at his home the night of March 4th, 1992, Beverly went home. She returned the next morning and discovered his body lying on a couch in the library with his gun nearby. The police examiner concluded that his death was a suicide, but a Virginia State Police agent ignored a forensic report corroborating the suicide death and focused on Beverly, using the pretext of being empathic while attempting to manipulate her memory to convince her that her deep grief was the result of having been unable to prevent the suicide and that she must have been present and blocked out the traumatic event. At trial, prosecutors and police concealed the forensic report and other evidence which contradicted their theory, and relied on the state agent's claim that Beverly had made a statement of being there, and which they called tantamount to a confession. Beverly was convicted of first-degree murder and sentenced to 22 years in prison. She was exonerated in 2003 based on her legal team's discovery of evidence that had been illegally withheld at her trial, including forensic reports which clearly showed that Roger's death was a suicide. The federal judge who reversed her conviction called the questioning that led to her conviction deceitful and manipulative, and branded the case a monument to prosecutorial indiscretions and mishandling. Sabrina Butler was a 17-year-old mother when her 9-month-old son stopped breathing. She tried to resuscitate him and rushed him to the hospital. The baby had serious internal injuries and died. Sabrina was questioned by medical personnel and police several times during the early morning hours following her bringing the baby to the hospital, including when she voluntarily went to the police department. She was interrogated without a family member or an attorney present. She gave various different versions of what happened and finally gave a statement that she had hit the baby in the abdomen. After giving this statement, she was arrested and charged with capital murder. Her attorney did not call any witnesses, but simply cross-examined the prosecution's witnesses. She was convicted, sentenced to death, and her execution date was set. She was the only woman on Mississippi's death row. The Mississippi Supreme Court overturned her conviction and granted her a new trial. At her second trial, neighbors testified about her attempts to perform CPR on the baby, and a medical expert testified the injuries could have been caused by those efforts to save the child, and that the child also had a pre-existing heart condition and kidney disease. Now, when you look at these cases that I just talked about, there are certain factors that appear in all of them. In all of them, the women went willingly to the police station. They all talked at length with the police several times without an attorney. They were eager to help. They were eager to please. They were stressed by the shock of someone close to them dying suddenly. And they did not understand until much too late that they might be viewed as a potential suspect. And this is really understandable, because when you listen to these cases, no crime was committed in any of them, so why would they think that they were a suspect? In any event, we are running a little short on time, so I'm going to go ahead into reentry issues for women who have been wrongfully convicted. Wrongful convictions in many cases have taken the best years of exonerees' lives. It is not easy to transition to life outside of prison. They have been traumatized and have immediate physical needs, such as finding housing, medical attention, employment and training, and emergency financial support. Some of them face the challenge of reuniting with children who also suffered from their mother's imprisonment. Many suffer from symptoms of PTSD, including trouble sleeping, recurrent nightmares, and hypervigilance. One of our female exonerees has PTSD to the extent that she requires a service dog to be with her at all times. This dog is extremely helpful to her. We have known both male and female exonerees, of course, through our work. And the men are traumatized also. And we don't mean in any way to take away from their horrible experiences. But it seems like the women have an even more difficult time after leaving prison. Perhaps in our cases, because they frequently lost a loved one or a child. Sometimes family members have died while they were in prison. They couldn't attend the funerals. They couldn't grieve with other family members. Wrongfully convicted people are usually abruptly set free, after years of imprisonment without any time for pre-release programs. They generally do not qualify for the post-release programs that are in place for parolees who actually had committed crimes and served their time. Exonerees re-enter society without transitional services, social support, or even a parole officer. Exonerees and their attorneys are on their own. So in other words, sometimes an innocent exoneree really leaves in a worse situation than if they'd been a guilty person that had served their time. The wrongful conviction is not automatically expunged from the exoneree's criminal record, and they have to constantly explain their status to prospective employers or landlords who view them as ex-cons. And believe me, it is more of a stigma for a woman to be an ex-con. At our project, we have a social worker / attorney who works with some other areas at the legal clinic also, but she is working with these women and helping them communicate with each other so they can support each other and share information. We're planning a small conference in November at the law school, and if we are able to raise the funds, thank you, if we're able to raise the funds, we'd like to pay the travel expenses of female exonerees from other states so they can attend. Some of our other future plans include finding funding for counseling and other reentry services for exonerated women, to represent women in selected cases, and to encourage potential research in these areas. And now I'd like to thank you all very much for your attention and open it up for questions.
And of course, I would encourage State's Attorney Nierheim and Representative Drury to come up as well and take questions or comment
Yes.
on anything.
That's interesting. I have the statistic for 33% of the women were convicted of crimes that didn't occur because they happened from an accident, like you said. For the other, what's the math? 67.
And those don't count the child sex abuse hysteria cases.
So that leaves about 33% of women's cases where there was a crime convicted, and I don't have the breakdown of that 33% of where they were able to find another suspect or find the real perpetrator. So it's difficult to answer your question precisely, but it's an interesting question.
In the back, either one of you, go ahead. The question is, I'll repeat it for the TV, is after people are exonerated, what does the state do to help them re-enter society?
Well, I can go there. So the certificate of innocence is granted only for women who can, and men, who can establish actual innocence. And if they do that, it comes along with what I consider to be a modest award. For example, Julie, she served 2 years in prison. She got somewhere on the order of $60-something thousand. I just had a client who just got a certificate of innocence last week. He served 13 years in prison. He's going to get $170,000. So that comes with it. It's a no-fault award. Since I have Representative Drury here, some states don't have any compensation, but of those that do, we're a bit on the low end. We might want to look to Texas, which does everything big. They execute people in a big way, but they've had, I think, the most exonerations, but they also have the most generous compensation. There are some provisions that really, in my opinion, aren't that effective that go with the compensation, such as supposed job placement help, but I've never actually seen anybody benefit from that. And I always like to point out, too, that if someone like, say, Julie, who was sentenced to 50 years in prison, when she gets out, she has just saved the state of Illinois. Well, let's see, she had 48 years left on her sentence at about $25,000 per year that it costs to keep somebody locked up. So the state came out way ahead in her case.
But I would just like to add that even if you were innocent and you were exonerated, that does not automatically mean that you will succeed in a certificate of innocence petition. I mean, that's obviously the hope. But, you know, I think that some counties and some judges are you know, taking a very strict look in terms of what's required to show that the person is actually innocent. So, and if you do not succeed in a certificate of innocence petition, you get nothing.
Although, shout out to Representative Drury again. I think you're the co-sponsor of, yes, one of the co-sponsors of, there is a current bill that would make the whole certificate of innocence and then the compensation automatic in certain cases where actual innocence was the reason that the conviction was overturned in the first place. So that could be really, really helpful.
That would be great. We hope that gets enacted.
I'm just going to ask, in the Juan Rivera case, weren't there some damages that were paid to him, Mike? Through a civil action, so that's another way to
That's a
pursue
possibility,
damage.
but again, a person can be innocent, and that does not necessarily mean that they will prevail in a civil action. I mean, you read about cases where people have, and they do sometimes, but it's not a guarantee.
Actually, Juan Rivera either has filed or is about to file a petition for a certificate of innocence.
Where is that filed? In the circuit court where they were convicted, or is that a new case?
It's filed in the circuit court, and depending on jurisdiction, it's really up to the chief judge in that jurisdiction to decide whether it would go back to the same judge or a different judge.
But is it a civil case or is it a criminal case?
It's in the Code of Civil Procedure. In Cook County, it stays in the criminal division, and those judges consider it part of this criminal case. In other jurisdictions, it's considered a new civil matter and is handled under the civil rules of procedure.
There's a question right here.
I'm just curious about if you're exonerated but you're not innocent. Is there something about the presumption of innocence that it would revert back to? I mean, I just don't. If somebody's guilty, they should be put away. If they're not guilty, then they should have the same certificate. I don't understand how they can make that difference.
All right, well, thank you.
Let me repeat the question. The question, it's just for the TV, because they don't pick up the other questions. So the question has to do with, isn't there a presumption of innocence? And so when someone is wrongfully convicted, aren't they automatically presumed innocent once again?
Well, I think you should run for the Illinois Supreme Court. It's a great debate because it's very, very difficult, especially if you don't have access to, well, who really did it, to prove innocence. But it really, the burden is on the petitioner, the way the law is written now, to actually take the extra step and prove innocence. If I were to suggest some additional legislation, I would suggest that in these cases, if a person has been to prison and the conviction has been thrown out, that there be a presumption of innocence. And at that point, it should be on the prosecutor to come forward with a little evidence of guilt. Maybe not enough to convict them, and I'll give you an example of the type of case you wouldn't want to compensate someone, and that might be a case, let's say a drug case, where the reason the conviction was set aside was because maybe the police did something wrong when they executed a search warrant, and so the drugs couldn't be used at trial. I mean, that person's guilty, but their conviction was set aside, so you don't want that person to be compensated. So in that case, there'd be a presumption of innocence, but then the state's attorney could come in and say, well, yeah, he really did have all these drugs, so we shouldn't compensate him. But if everything is zeroed out and we're starting at ground zero again, I couldn't agree more that that person should be presumed innocent, and if they went to prison and now they're out, they should get compensation. It's a great question. Thank you.
Because, to prevent them from, having access to employment and housing, and everything else with the stigmatism of the conviction, that's now been overturned, that just, I don't know so much about compensation as just being able to have a certificate.
Right, and Julie never sued anybody over her case civilly. I mean, she did get the compensation, but what she says and what so many of our clients say is just that the certificate of innocence, and in some cases, a pardon based on innocence from the governor is just so important to them and going on with their life. But we kind of like the certificate of innocence better because it's from a court and it has actual standards and it's not tied up in politics the way the innocence pardon is.
There's a question in the back of the room again. The question is, with regard to the certificate of innocence, how do you really distinguish between a person who's actually innocent or whose case didn't succeed because there was a faulty gathering of evidence or something?
Well, we are very fortunate at the Center on Wrongful Convictions because we have the luxury of only accepting the cases that we want to accept, and we screen them very, very carefully and investigate them. So we don't even get involved in a case unless we think it's very clear that the person is innocent. So I understand what you're saying, but we've already done that before we even get involved in the case.
And then I don't know if this would address your question too, but 'cause I did criminal appeals for many years as a public appellate defender, and I would get cases overturned for similar reasons, prosecutor error at trial or a bad lawyer or whatever. And then the state's attorney has the option of, in that situation, of taking the person to trial again. And I gotta say, I would say in the majority of my cases where I got convictions set aside, they got convicted again. But if something happens, in the meantime where there is actually additional evidence of innocence that wasn't there at the first trial, those are the types of cases that we're talking about that are suggested for the exoneration registry. And those are typically cases where either there is a retrial and the person's acquitted, so there is a difference between the two trials, or the state's attorney's office reevaluates the case and elects not to proceed again. And I will grant that doesn't always mean that the person is innocent, but I guess we go back to what is your presumption at that time, and that's a great question for a debate. Well, if I ran the world, they would, but of course there is the opportunity for either the Illinois Attorney General's office or the state's attorneys to get involved in the case and to advocate the other way.
Are we supposed to be wrapping up at 5? Mary? So we'll just take, we're a little after 5, but there are some pending questions. So I'm just going to take 2 more questions, one right here.
Were any of these women read their Miranda rights, especially the woman who was questioned for 27 hours?
The question is, were any of these women read their Miranda rights, especially the woman who was questioned for 27 hours?
Well, yes, I believe that they were, but I just want to say something about why it's good that interrogations are now being videotaped, because in that particular case, Nicole Harris' case, she was questioned, off and on for 27 hours, and then they started recording at the point when she was broken and she was confessing. So if that earlier period had been taped, they might very well have not chosen to proceed against her.
Did you say what percentage of people that have been exonerated get the certificate? Did you say that?
We did not give that as a statistic.
That's something that we've been looking at. It's an interest I have, and I don't think it should be that difficult, just to see if women are compensated at a different rate than men across the nation, and that is actually something that we're going to put together.
I'm going to take the final question from the back of the room.
I was wondering, concerning projects such as this, project where there is presumption of innocence at the end, how often does the state choose to refile the charges and take people to trial once again? Are there any statistics on that?
The question is, are there statistics on how frequently these women are retried after the Innocence Project gets involved and may prove their innocence?
We don't have a precise statistic, but it happens quite often that a person whose conviction was overturned based on new evidence of actual innocence is retried, and then they are acquitted, hopefully, if they're actually innocent at trial. But often prosecutors decide to drop the charges at that point because they no longer have enough evidence to proceed with a retrial.
And thank you. And on behalf of the American Association of University Women, wait, Mary, did you want to say something?
Yes, there's a reception now, immediately following, just go out here to the door and then take a right and go down the hallway.
There is a reception immediately following down the right to the hallway, and I'm sure that some of our guests will be staying with us, and so hopefully you can ask any questions that you didn't get an opportunity to ask here. And then once again, I want to thank Karen Daniel and Judy Royal and Erin Topp for being with us today and sharing this their expertise with us in a very enlightening program and something that's very relevant to all of us. And on behalf of the American Association of University Women, Waukegan area, the Lake County Bar Association, the Lake County Bar Foundation, the League of Women Voters of Lake County, and Lake Forest College Ethics Center, I want to thank you all for attending today. Thank you very much.